Family Law Test number 4 for the 2019 version. Proceedings under Article 10 may be originated in the county where the child resides at the time the petition is filed, or in which the person having custody of the child resides or is domiciled at the time the petition is filed. At the time the petition is filed. So it was either B or C. The key is at the time the petition is filed. 1022 and 1027, when a child has been removed without a court order, so that's 1022, because 1022 is pre-petition removal with no court order. Pursuant to 1022, the family court shall hold a hearing the next day family court's in session after the filing of the petition to determine whether a child should be returned. So again, this is what it should say everywhere. None of that 72 hours crap or whatever. It's the hearing has to be held the next day family court's in session, period. This is the thing, if you listen to the other video, you heard me freaking out about when I went over it in class. So number 3, the answer was D, A or B, because it's upon the application of a parent or attorney for child for an order that returns the child, which is described in FCA 1028, the family court shall hold a hearing to determine whether the child should be returned, and the times they have to do it is when there's good cause, or if the parent had a hearing already where they were present pursuant to 1027 and they had the opportunity to be represented by counsel, then the family court does not have to hold a hearing. Another 1028, except for good cause shown, the hearing described in question number 3, so that's the hearing to return the child, should be held within 3 court days. Hearing to return the child shall be held within 3 court days of the application and shall not be adjourned. So this is, again, a hearing to return the child after removal pursuant to FCA 1028. The hearing shall be held within 3 court days of the application, and except for good cause shown, it shall not be adjourned. And good cause does not count as the calendar is full. All right, 1036. In cases involving abuse, the petition and summons shall be served within 2 court days after issuance. If they cannot be served within that time, such facts shall be reported to the court within 3 court days, and the court shall thereafter issue a warrant. So this is only for a case involving abuse. In cases involving abuse, the summons and petition shall be served within 2 days after issuance. If they cannot be served within that time, such facts shall be reported to the court within 3 days after issuance, and the court shall thereafter issue a warrant. So this is only for cases involving abuse. Issuance of the warrant described in question 5 is not required when process is sent without the state as provided in 1036 sub C. So when process is sent without the state, the summons and petition have to be served within 10 days after issuance, and the warrant is not required. Okay, 7, this was a select all correct answers question. So who may originate a proceeding under Article 10 of the Family Court Act? And you should have gotten only answers A and D, a child protective agency or a person on the court's direction. Now, if you didn't get this one, go back and watch Angela's video on who may originate. And you will just watch that video a couple times or until you memorize it and you'll get it. Number 8. 1039. If the court on its own motion, or another way to say this is sua sponte. Sua sponte is a Latin phrase on its own motion. The court wants to order an ACD in an Article 10 case. Who must consent? C, petitioner, respondent, and the child's attorney. Another interesting thing about an ACD in Article 10 is that they can extend it forever on consent. Okay, now we're into Article 11, which is appeals, for the next couple of questions. And the first one says an appeal may be taken as a matter of right from any order under the Family Court Act, and that is false because it's only under a final order Unless it's a case involving abuse, then you have, as a matter of right, you can file any appeal, even an interlocutory order. So an interlocutory order is just a non-final order. Okay, so in a case involving abuse, you can always file the appeal. Otherwise, it has to be a final order, or the appellate division has to give you permission. All right, so number 10, FCA 1111, an appeal from a final order of the family court is brought to the appellate division, period. So it's always the appellate division when you're going to talk about family court appeals. Another appeals question, a party appealing a family court matter shall file 2 copies of such notice of appeal with the family court clerk. Number 12, 1036. Okay, this had no right answer. It's 10 days after issuance. All right, I apologize. I thought this is a really hard question. I thought that I took this out of here, but I didn't. What you had to do was you had to know how it works when process is sent without the state in 306 of the CPLR. I didn't expect you to know that, but it's basically, for a case involving abuse, it has to be within 10 days after issuance, and within a summons and complaint, it's the same method as the CPLR, which would be, skip this fucking question. And what you are looking at here is Family Court Act 1036, Subdivision C. So as you can see here, it's talking about in cases involving either abuse or neglect, the court can send process without the state to a non-domiciliary in the same manner as in 301 or 302 of the CPLR, notwithstanding that that person is a non-resident or non-domiciliary, as long as you have these 2 things. You have to have that the abuse or neglect, the alleged abuse or neglect, occurred within the state, and that the child is a resident or a domiciliary of the state at the time the petition is filed. Okay, so next I have, so 12 was really hard. Just know that in cases involving abuse, that it's 10 days after issuance. Okay. Number 13, if the family court, as a part of its order of disposition in an Article 10 case, orders a child placed in foster care, the initial period of placement is D, none of the above, because the order is in effect until the court completes the initial permanency hearing. And, stupid, because they have rules about when the court has to complete the hearing, but just know that there's no actual time period. It's until the court completes the initial permanency hearing. So even though generally the initial permanency hearing has to be scheduled for 8 months from when the child was first removed, there's no actual time period for this placement order. In the case of a substantial failure of a material condition in a surrender agreement. So a surrender agreement is where someone's like giving up their child for adoption. And there's an agreement about what's going to happen when the child's adopted. But if there's a substantial failure of a material condition in that agreement, if the authorized agency does not file a petition as a result of that failure, the parent or the child's attorney may file such petition at any time up to 60 days after notification of the failure. And the answer is they have up to 60 days, but it has to be before the child's actually adopted. So 60 days, they have up to 60 days after notification of the failure. And the other thing to note here is that the authorized agency is supposed to take action within 30 days. But if they don't, then the parent or child's attorney can do it up to 60 days after notification of the failure. And number 15, the prefix for foster care review is K. So some of the ones that I want you to remember are B is for bad parents. So B is for commitment of the guardianship and custody of a child to an authorized agency. So that's B. S is for supervision, person in need of supervision, or Article 7 PINs. L is approval of foster care placement, so approval, L. And F is for support. So F, think of financials. So F. And another weird one is Z for miscellaneous. Okay, so proceedings under Article 10 may be originated in the county where the child resides at the time the petition is filed, or in which the person having custody of the child resides or is domiciled at the time the petition is filed. At the time the petition is filed. So it was either B or C. The key is at the time the petition is filed. 1022 and 1027, when a child has been removed without a court order, so that's 1022, because 1022 is pre-petition removal with no court order. Pursuant to 1022, the family court shall hold a hearing the next day family court's in session after the filing of the petition to determine whether a child should be returned.